Hi, everybody. Thank you so much for joining us for this workshop. This housing workshop, we are going to begin with a land acknowledgement. My name is Susanna Lee Kandikati, and I would like to acknowledge the land that I come to you as a settler on, this Aina, who now calls the Ahupua'a of Waimanalo home. I can currently trace my family's roots to Seoul, Korea. I would like to begin by acknowledging that the Aina of Pili Pili, on which we would be gathering if in person, is part of the larger territory recognized by Indigenous Hawaiians as their ancestral grandmother, Papa Hanaumoku. I recognize that Her Majesty Queen Liliuokalani yielded the Hawaiian Kingdom and these territories under duress and protest to the United States to avoid the bloodshed of her people. I further recognize that Hawaii remains an illegally occupied state of America. I recognize that each moment that I am in Hawaii, she nourishes and gifts me with the opportunity to breathe her air, eat from her soils, drink from her waters, bathe in her sun, swim in her oceans, be kissed by her rains, and be embraced by her winds. I further recognize that generations of Indigenous Hawaiians and their knowledge systems shaped Hawaii in sustainable ways that allows me to enjoy these gifts today. For this, I am grateful, and as a settler, I seek to support the varied strategies that the Indigenous peoples of Hawaii are using to protect their land and their communities, and I commit to dedicating time and resources to working in solidarity. Mahalo.
Awesome. Thank you so much, Susanna. We are now going to get started. And so first, I would like to take a moment to tell everyone a little bit about AAUW for those of you who don't know. My name is Vanya Steinbach, and I'm here with my coworker, Susanna Kandikati. We are interns for the American Association of University Women, or AAUW for short. And AAUW is a national program. We are a part of the Honolulu branch, in addition to being an RIO, or a registered independent organization here on campus at UH Manoa. AAUW's mission is to create a more equitable society by providing the tools necessary for women to gain economic security, pursue their education, and advocate for women's rights. We focus on women's issues, but our RIO is open to everyone. Now tonight we are doing the housing workshop, and the reason that we are doing this, or part of the reason why I was especially interested in organizing this, is because my first year at UH Manoa, I was in the freshman dorms, but during the pandemic, I had to move to off-campus housing, and it was quite a daunting task, and there's a lot I didn't know and still don't know. And finding safe and affordable housing is a challenge, especially to young women, first-time renters, and students. And so the goal of this workshop is really to help anyone who will ever or has ever been a renter. And with that, we would like to thank our three speakers for being here today. We were extremely grateful for Cynthia Moore, Nicholas Severson, and Katie Ranny. And I will now do quick introductions. Cynthia Moore is a staff attorney with the Housing and Consumer Unit at the Legal Aid Society of Hawaii. Her current legal practice includes housing discrimination cases and general landlord-tenant disputes. Before joining the Housing and Consumer Unit, she was a staff attorney at Legal Aid's Kauai office. She obtained her Juris Doctor from Syracuse University College of Law in 2019. Prior to her legal career, she received a master's in social work with an emphasis in gerontology from the University of Hawaii at Manoa. Nicholas Severson is a staff attorney with the Housing and Consumer Unit at the Legal Aid Society of Hawaii. His practice includes housing discrimination cases and general landlord-tenant disputes as well. He previously served as a staff attorney in the Legal Aid's Maui office. Prior to graduating from Villanova University's Charles Widger School of Law in 2019, he worked in higher education administration at Drexel University and the University of Wyoming. Katie Ranny is a peace builder, facilitator, and conflict resolver. She's currently working as the Program Development Director of the Mediation Center of the Pacific, where she is responsible for managing existing special programs and creating new programs as community need dictates, as well as conducting outreach and training. Before MCP, Katie worked as an independent facilitator and communication consultant, mostly with nonprofits and government agencies, to create substantial plans to strengthen and advance their endeavors. She graduated summa cum laude from Santa Clara University and earned her master's in communication from UH Manoa with a graduate certificate in conflict resolution. Thank you so much for being here. And with that, I'm going to hand it over to the Legal Aid Society.
Thank you very much, and thank you for having us be a part of this presentation. As previously mentioned, my name is Nick Severson. I'm a staff attorney with the Legal Aid Society of Hawaii. So today we're going to cover a lot of ground here in a relatively short amount of time. So we're going to get into some general landlord-tenant concepts, which would apply for anyone seeking off-campus housing, as well as some fair housing concepts. So understanding discrimination law, and a bit of an overview as to what to expect, in terms of what you might encounter trying to rent a place for the first time. So we are both with Legal Aid Society of Hawaii. It's the state's oldest and largest nonprofit law firm, and we are dedicated to helping the most vulnerable in our society. We have offices on each of the major islands, and you can see our contact information on the screen there. So if you would like to apply for services or just learn more information about what we do and the type of folks that we help, that information can be available to you there. So with that, Cynthia.
So just wanted to give a little disclaimer here. So any statements that we're making today are solely for the purpose of legal information. We can't give you any advice, but if you would like to apply for our services, you can call our intake line, which was on the previous slide. We'll show it again. And you can see my contact, or our website is actually behind my head on the blue screen. So, any questions that we're asking in the Q&A, just know that we can't give you any legal advice pertaining to any specific, situations that may apply. So I'm going to talk a little bit about the Residential Landlord Tenant Code now, which falls under the Hawaii Revised Statutes 521. And you can see the website down here. You can go there and look at that statute if you'd like. So who does the Landlord Tenant Code apply to? So I guess first I'll cover who it doesn't apply to, which unfortunately doesn't apply to dorms at UH or any other colleges or universities in the state. It also doesn't apply to any private dorm management companies that host a minimum of 50 plus beds. It also doesn't apply to hotels or shelters or transitional housing. And there are other types of housing that it actually doesn't apply to as well, but for the purposes of this presentation, we only included the more relevant ones. The important thing to note is that it does apply to residential leases. So if the landlord owns and is renting out the unit, whether that's a portion of the unit or the entire unit. So now we're going to talk about leases. I'm sure a lot of you are familiar with the concept of a lease, but a lot of people don't know that a lease can be oral. So you can be living somewhere and have an oral agreement to rent a space. Usually those are handled as month-to-month agreements, so month-to-month tenancy. A lease can also be written either with a fixed term. So for example, like 6-month term lease or a 1-year term lease, or you can have a month-to-month term lease. You can also have week-to-week, but that's pretty rare. And usually a fixed term lease has the lease termination date built in, which may or may not include some special language, like it converts automatically to a month-to-month lease afterwards. So it's important to, just be aware of that. Also, one thing to note is that a written lease cannot be beyond 1 year. So we're going to talk about some important topics like rent increases. So for a fixed term lease, a landlord or a housing provider cannot change the rental amount during the fixed term. After the fixed term, they may, but not during that term. So if you have a 6-month lease, your landlord can't raise your rent during those 6 months. For a month-to-month tenancy, your landlord can increase your rent with 45 days notice. If the tenant agrees, then they have to pay the higher amount. If not, it essentially would act as a termination notice likely. And then for less than month-to-month, which like I said is pretty rare, it can increase with 15 days notice. Also at the bottom, you'll see there's no rent control in Hawaii. So there's no limit to how high rent can be increased, or, as I don't know if we have any Office fans here, but as Michael Scott once said, you have no idea how high it can fly. So unfortunately, for a lot of students, that just makes living here even more difficult. So we're going to talk about repairs, because that's something that a lot of people have to deal with. So one thing to note is when you need a repair, the tenant must notify the landlord of the issue in writing. The landlord then has 12 days to start the repair or inform the tenant regarding the delay. And when I say in writing, it can include texts or emails. It doesn't always have to be like a written letter. If the landlord fails to make the repair, the tenant can do what's called repair and deduct off up to $500 off from the rent. But the tenant can only do this every 6 months. So anytime you're making a request for repair and your landlord is not doing it, you should include all known problems in the notice to request the repair. And then if you're doing repair and deduct, it can't exceed 3 months rent during the 6-month period. And then the issues for repair include problems either caused by tenants or guests. The person who's responsible for the repair can vary, whether it's caused by just a defect in the property or whether it's caused by the tenant. So now I'm going to turn it over to Nick to talk about termination of month-to-month leases.
All right, so a month-to-month lease is going to be typically a pretty common situation that folks find themselves in, either because they enter into a month-to-month lease or because they have a fixed term lease, like Cynthia said, either a 6-month lease or a year lease that converts automatically to a month-to-month lease. So termination can happen either on the landlord side of things or on the tenant side of things, but it's important to understand exactly what that notice of termination needs to contain. So if the landlord is terminating a month-to-month lease, they're required to provide 45 days notice, and that needs to be in writing. So it needs to be a written notice, and there doesn't need to be a reason. So oftentimes people think I'm a good tenant, I've been paying my rent on time, I haven't caused any issues, how can they terminate my lease? Unfortunately, the way that our state law is written, if they give the proper 45 days notice, it can be for any reason or really no reason at all. The middle column here is a little bit less common. So there's a specific 120-day notice requirement if there's some sort of voluntary demolition occurring on the property, or if the property is being converted to a vacation rental. It's possible that you'd have that circumstance, in which case the landlord would be required to give 120 days notice, which obviously differs from the 45-day notice that would typically be standard for the landlord. And lastly, as a tenant, if you wish to terminate your month-to-month lease, move elsewhere because you're moving off island, whatever the case may be, you're only required to give a 28-day notice. And again, that's got to be given in writing. And you're required to pay, obviously, through the amount of time that you remain living there. So, if you pay, if you're living there for another 28 days, you're still paying those 28 days of rent, right? Next slide. All right, so Another thing to be mindful of, another grounds for termination of a lease would be if there are violations of the lease, right? So if the landlord notices that there are maybe certain issues with your tenancy, maybe it's unauthorized guests, maybe it's people that are living in the unit that aren't on the lease, maybe it's some sort of violation for noise, or we imagine a few different circumstances. The landlord is required to give a 10-day notice, and that's pursuant to Hawaii Revised Statute section 521.72. And what the 10-day notice is, it's a written notice, and it basically says you have 10 days to either correct the problem or vacate the unit. So if you receive a notice like this, really the takeaway is that you have to address the issue within that specified 10-day time frame. Otherwise, if you do not correct that issue and the violation is ongoing and continuous, at that point the landlord can take and file to evict you in court. So important again to receive a notice like that and know that some corrective action needs to be taken at that point. Next slide. All right, so we'll talk a little bit about Act 57. This is a little bit of a current state of the world slide. This slide won't be relevant for a whole lot longer, but we'll talk about it now because it's really important for the time being. So right now there's a law in effect called Act 57. And basically what it requires is that if a landlord is attempting to evict you for non-payment of rent, meaning that if you are 1 or more months behind on your rental payment, they're required to give you a 15-day notice. And that 15-day notice is very specific, and there's again this entire law that governs what's required in this notice. But effectively, the goal is to get the parties to mediate and try to resolve the matter for filing a court action and going through the court process. So if you have fallen behind on rent and you receive a notice that it's a 5-day notice or a 10-day notice or anything like that, it's not going to be a valid legal notice at least until August 6th. The law will change at that point. But if you do receive a 15-day notice, it's important that you follow through and reach out to the Mediation Center of the Pacific, which you'll hear more about later in this presentation, and start the process of trying to mediate the matter. Also important to note that there is a great deal of rental assistance still available. So if you find yourself in a situation where you do owe rents and you've received a 15-day notice, or even prior to receiving a notice, if you know you've fallen behind, there's rental relief available. Next slide. All right, so another kind of topic we want to hit on here, and thanks for bearing with our little bit rapid fire nature. It's a lot to cover in a short period of time. We want to make sure that we equip you with as many tools as we can here. But subleases and assignments, obviously that's a college situation, a common situation that you may encounter in college. You're going elsewhere for a summer internship. You are moving in with different friends. You may want to find someone else to take over your lease. It's really important to understand what your lease says, right? So if there's no written rental agreement, you're permitted to sublet your unit without your landlord's consent. However, if there is a written rental agreement, it may specify otherwise. So if your rental agreement says that you can't sublease your unit, unfortunately, if you do go ahead and sublease your unit, there's going to be potential consequences for that. Could be evicted, that type of thing. So just be mindful of what your lease says and understand that if you are in a situation where you need to, depart prior to the end of your lease and you want to explore a sublease situation, it's really imperative that you review the lease and see what it says. All right, so time has come to talk about security deposits. This is a very common and important topic, especially given it's a lot of money to be tied up with the landlord. It's important to know what's required and also how to get that money back on the back end, right? So on the front end of things, the security deposit can't exceed 1 month's rent. So if your rent is $1,500 and your landlord tries to charge you a $2,000 security deposit, that's a problem, violates the law. They're only entitled to charge you up to 1 month's rent. There is a limited exception if there is a pet. They can charge a little bit more, as you see there on the screen, but that would only be in that limited circumstance. The security deposit is supposed to be used to, cover any damage that you would cause in the unit, or cover any things that weren't paid while you were a tenant there. It's not meant to be your last month's rent, unless there's some sort of express agreement between landlord and tenant that says that it would be used for that. Next slide. So after you vacate, at that point, the landlord is required to either return your security deposit or provide a written notice explaining why they've withheld some or all of your security deposit within 14 days of vacating the unit. So within 2 weeks after you vacated, you should be expecting either the return of your security deposit or at least some statement explaining why, whether it was repairing this thing that was broken in the unit, or you were $500 behind on rent, so they kept $500 for that. Whatever it may be, should be explained within that time period. If the landlord withholds the security deposit, there's some recourse that a tenant may have, right? So if the landlord withholds the security deposit, a tenant would be entitled to file a claim in small claims court to pursue whatever was withheld. If the landlord is found to have wrongfully or willfully withheld the security deposit, the provision in the statute would provide that the tenant could obtain 3 times the security deposit. So if your security deposit was $1,500, if the landlord was vindictive and retaliatory and withheld it for no justified reason, the court could order them to pay 3 times the cost. Important to note that you have 1 year from the lease termination to file that claim. So if the landlord does withhold your security deposit, you have a year to pursue it. If you don't pursue it within that year time period, unfortunately, there's nothing you can do about it. You're going to be out of luck. Also important to note that in small claims court with security deposit claims, there's no attorneys involved. So the landlord can't have an attorney, you can't have an attorney. It's just going to be a legal proceeding between the tenant, the landlord, and the judge. On kind of a related topic to security deposits, just going to briefly cover kind of what you should expect both moving in and moving out of a property. It's really important to cover your bases and make sure that you understand the condition of the property that you are about to occupy, as well as the property that you are vacating, right? So when you move in, there should be some type of detailed inventory where you have the chance to note any issues that are existing in the property, right? There's this big mark on the floor, there's a hole in the wall here, the fridge is making this terrible sound, whatever it may be. You should be able to document that, because that'll be really important when you move out and the landlord says, hey, you damaged the floor, you did this. You want to be able to point to this inventory and say, well, actually, that existed when I moved in, right? So that's really important. Same on move out, right? So you should take good photos, both when you move in and move out. Also wise to do a move out inspection and note, what was there before as well. And important to note too, a tenant is allowed reasonable wear and tear. So if you live in a unit for 2-3 years, the expectation isn't that it's going to be exactly the same, right? There might be some minor things that just come with day-to-day living in a space. But it's really important that you document this both in the paper trail, like we're saying here with the move-in inspection, move out walkthrough, as well as pictures taken on both ends. That way, if the landlord does withhold your security deposit, or if there's some other dispute, you have the type of evidence you would need to pursue your rights and remedies there. All right, back to you, Cynthia.
All right, so we're going to talk a little bit about fair housing now. We were talking about residential landlord tenant code. Fair housing is a whole other set of law that covers, well, it's both state and federal. So the federal laws are cited there. You can see 42 USC 1604, and then the Hawaii Fair Housing Law is covered under Hawaii Revised Statute sections 368 and 515. So both laws are relatively similar in what they're stating. They protect people from discrimination when they're renting, buying a home, getting a mortgage, doing any sort of housing related services. It prohibits discriminatory practices by a housing provider based on what we'll talk about now, which are protected classes. So what are the protected classes that are covered? Under Hawaii law and federal law, you can see they're both going into this house. So all of these apply to someone. The protected classes here are age, which can be young or old, ancestry, HIV status, Hanai status. That is a concept that's specific to Hawaii, where someone takes a child into their home. They don't have to have any specific papers or court documents saying that they have permission to take care of the child. But if a person is being discriminated against because of their Hanai status, or they have a child who is not potentially blood related to them, then that would fall under that protected class. Also includes marital status, gender identity, gender expression. Gender identity is how you personally identify. Gender expression is how the world views your gender expression, and then sexual orientation. And then some of the federally protected classes are sex, race, color, religion, disability, familial status, which is any person with children in the home under the age of 18, or national origin. And we'll probably dig in a little bit more during this presentation regarding sex and disability. Disability is one of the biggest things that comes up for us. So we'll talk a little bit now about sexual harassment in housing. Sexual harassment is viewed as a form of sex discrimination. This includes unwanted sexual advances, requests for sexual favors, or other unwelcome verbal or physical conduct of a sexual nature. So as you can see, the two general types would be quid pro quo sexual harassment, which would be like someone putting conditions on housing or housing related services for sexual conduct. So if your landlord approaches you and offers sexual favors for reduced rent, that would be sexual harassment in the form of quid pro quo. Words are hard. There's also hostile environment. So that's harassment that's severe and pervasive enough that it interferes with a person's ability to access and live in housing. So if your landlord is stalking you or leering in your windows, it's important to note that that may be viewed as a form of sexual harassment. And then there's domestic violence. Domestic violence is also viewed as a form of sex discrimination. And that's because, women are 5 to 8 times more likely than men to be victimized by an intimate partner. 85% of victims of intimate partner violence are women. And among people who rent their homes, women are 7.4 times as likely as men to be victims of domestic violence. This doesn't mean that if you're a man and experiencing domestic violence, you wouldn't be covered under the Fair Housing Act. It just is viewed as falling underneath sex discrimination. And then we're gonna take a quick aside, go back to the Residential Landlord Tenant Code. So there are remedies for you if you're experiencing domestic violence or abuse and you need to leave your housing because of that, or if you need to change your locks. So as you can see, the statutes here provided, HRS 521-80 states that you can terminate a rental agreement without penalty or fees. But it's important to note that there are specific ways for you to do that. So you can call us or talk to someone who is an attorney to get advice about that. If the court has ordered like a temporary restraining order or protective order. It's just important to note that neither the landlord or the tenant has the duty to allow access to this person, even if they're a tenant, or provide the person with keys. And then finally, the landlord can require, or the tenant can require the landlord to change the locks by submitting a request to the landlord to do so. And as always, we would suggest that you do that in writing. So who is subject to the Fair Housing Act? We talked a little bit before about who was and wasn't subject to the Residential Landlord Tenant Code. But it's important to note that fair housing applies to almost everyone. So it applies to homeless shelters, public housing, housing related services, public housing authorities, private housing. And there are more protections for people who are in public housing or, for example, receiving a voucher. Just because you're, for example, in dorms or living in a unit that may not fall under the Residential Landlord Tenant Code doesn't mean that the Fair Housing Act doesn't apply to you. So now I'm going to turn it over to Nick to talk a little bit about disability.
All right, so as Cynthia mentioned earlier, disability is something that we encounter a lot in our work. So disability, so if you go back to what Cynthia mentioned earlier about the different protected classes, disability discrimination complaints are the most common that we see in our office, and they're the most common basis for discrimination complaints, both with the Hawaii Civil Rights Commission, which is the state agency that enforces discrimination law, as well as the Department of Housing and Urban Development, which does the same thing on the federal level. So just important to be mindful of sort of some of the unique nuance of disability related protections under the Fair Housing Act and state fair housing law. So just a few different pieces on this slide here. So what a disability is under the Fair Housing Act is a physical or mental impairment that substantially limits one or more major life activities. We'll talk about this a little bit more on the next slide, but it's important to think of this definition in broad manner. Can also be regarded as having such an impairment, which we'll also get into a little bit going forward. So important to keep that in mind as well. And then recorded. So there's a record of such an impairment. This is pretty straightforward, right? There's a documentation paper trail that there's some type of, again, physical or mental impairment. Next slide. All right, so what again is disability under the Fair Housing Act? So as I mentioned, it's a physical or mental impairment that substantially limits, so that's considered to be significant or to a large degree, one or more major life activities, right? So you can see the examples that we have on the slide here. That could be a litany of things, right? So whether that's, walking, seeing, hearing, it can be the ability to bathe oneself, it can be a variety of things. But if there is a impairment that substantially limits any life activity, that can be considered a disability under the Fair Housing Act. Next slide. All right, so just to give a few examples and hopefully kind of broaden our thinking in terms of what can be considered a disability, right? So we have three individuals here on the screen just as kind of examples, right? So we have Arthur, who has anxiety, we have Benny, who has limited mobility, and we have Clarice, who has diabetes. All three of these individuals and each of these conditions could be considered disabilities, and each of these individuals could be considered disabled under the Fair Housing Act, right? So it's pretty easy to imagine how anxiety might limit one or more major life activity, right? Ability to process information or to deal with conflict, or what a variety of ways that could be the case. Benny, limited mobility, certainly walking is a major life activity. Limited mobility, pretty easy to see the connection there. And then Clarice with diabetes, certainly can imagine how diabetes might impact daily living. So these three examples are just examples, and again, just to kind of explain the broadness with which we want to think about disability in the fair housing context. But certainly all three of these individuals would be considered disabled under the Fair Housing Act. Next slide. All right, so going to spend a bit of time here on reasonable accommodation requests and reasonable modifications. So if someone with a disability wishes to make a change or exception or adjustment to a rule, policy, practice with their housing provider to be able to have an equal opportunity to enjoy and use their housing, they would make a reasonable accommodation request, right? So this is basically a request to the housing provider that something be modified or changed in order to make sure that they are able to enjoy their housing in the same way that someone without a disability would be able to, right? So just a few quick examples here on the screen, right? So one example of a reasonable accommodation request might be someone that is visually impaired having a seeing eye dog, right? So that's the first example on the far left there. Certainly it's easy to understand, even if there was, for example, a no pets policy, and we'll get into that later when Cynthia talks a little bit more about service animals and emotional support animals. It would obviously be essential for that person to be able to have that dog in order to fully enjoy their housing. Second slide there is an hourglass, and it's a little bit vague, but we're trying to make it as aesthetically pleasing and also talking points useful as possible. But this could be something related to time, right? So for example, if someone's disability limits their ability to process information in a way that might require, say, more time to pay their rent, for example. So if the rent is due on the 1st and for some reason their disability would make it challenging to do that, they might be able to make a reasonable accommodation request to pay their rent by the, say, 7th of each month, right? Or more time to provide certain paperwork, things like that. That's where that comes into play. Last example here is parking, right? So if someone has some sort of limited mobility, they might be able to make a reasonable accommodation request to have an assigned parking stall closer to their unit so that they don't have to, experience the mobility related challenges to get from wherever their regularly assigned parking space or unassigned parking space might be to their unit. So those are all examples of pretty standard reasonable accommodation requests that can be made. The second piece of this is a reasonable modification. We'll spend a little less time on this because it's a little less common, but this is similar to a reasonable accommodation request, but it is actually a structural change, right? So this is not just a change to policy, practice, procedure. This is a structural change to something about the unit or the building more broadly, okay? So again, a few examples on the bottom here. You might have, for someone that has issues with mobility, you might have grab bars in a shower, so they're able to get in and out of the shower more easily. That would be a modification. Second example there would be a wheelchair ramp into a unit to make it more accessible for that individual to get in and out of the unit. And then lastly, if someone is deaf, they wouldn't be able to hear a smoke alarm, for example. There might be a reasonable modification request to instead have a visual, a light alarm go off in the same circumstances that would alert them to the serious nature of whatever is happening in the building and would alert them to vacate. So if someone's making these requests, it's important to know that these can be made by anyone at any time in any manner, right? So there's no standard form that needs to be filled out. There's no magic words. You don't have to cite the statute. You don't have to, do anything particularly fancy. It's just a matter of making the request to the housing provider. So this can be done orally, it can be done in writing, it can be made by the individual making the request. It could also be made by a friend, family member, that type of thing. So in the event that someone makes a reasonable accommodation request, going back to earlier examples, let's say they make a reasonable accommodation request for more time to accomplish some type of task. The housing provider may request what's called a verification of need. So that is essentially a request for additional information that helps the housing provider understand why that reasonable accommodation is necessary to meet that individual's disability related needs. Next slide. So what does a verification of need need to say? It basically needs to say that the individual meets the Fair Housing Act's definition of handicap. It needs to describe the needed accommodation, right? So it needs to say, this person needs this thing. And then it needs to show the relationship between the disability and the request for accommodation, right? So it needs to say that granting this request would help meet this person's disability-related need. So that's what it's required to say. With that, I'll toss it over to Cynthia for a little bit more on service animals and assistance animals.
Thanks. So we're going to talk a little bit about assistance animals now. Assistance animals are not pets. So there are animals that do work, perform tasks, assist, or provide therapeutic emotional support for individuals with disabilities. So assistance animals is a broad term that covers both a service dog or a service animal or emotional support animal. And we'll go through the distinctions between each now. So a service dog means any dog that's individually trained to do work or perform a task for the benefit of an individual. So one very common example that people may be aware of is like a seeing eye dog. Whereas an emotional support animal is an animal that provides support that alleviates one or more symptoms of a person's disability. And you may see some spelling errors here. Those are intentional. They're supposed to be fun puns. So I hope you enjoy them. So for service dogs, not sure how applicable it may be to a lot of people here, but if a person has a service dog and their disability is readily apparent, so it's obvious that this person's service dog is doing work or performing a task for this person's individual disability, then they do not need to provide that verification of need that Nick was talking about earlier, so that no further inquiries are necessary or appropriate because it's obvious that it's a service animal. So your housing provider, if you have a service dog and it is apparent that it's a service animal, they shouldn't be requesting any sort of verification of need from a knowledgeable provider, so like from your doctor or anything like that. If your disability is not really readily apparent, your housing provider can ask the following questions. So they can ask if the animal is required because of a disability, and then they can ask what work or task the animal has been trained to perform. They shouldn't be asking any invasive questions about your disability, but they can ask about the training or what task your service dog has been trained to perform. If you answer both of those questions in the affirmative, no further inquiries are necessary or appropriate because it's obvious that it's a service animal. Oops. All right, so we're going to talk about emotional support animals. So emotional support animals can be any domesticated animal. So in Hawaii, we can't have emotional support snakes because snakes are not allowed. But it can be an emotional support bunny or, basically any animal that's domesticated. If you have an emotional support animal, you can make a reasonable accommodation request to your housing providers or your landlord or whoever. Unlike the service animal, emotional support animals do require a reasonable accommodation request to be made. And you may have an emotional support animal for an observable disability or a non-observable disability. If the disability is not observable, then information provided, you need to provide that verification of need from that knowledgeable provider. So you can ask your therapist or your doctor or someone who is knowledgeable of your disability, that you can ask them for that verification of need to provide to your housing provider. And then there also needs to be a showing of that disability related need. So show that connection or relationship between your disability and the need for the assistance animal. So make sure you include those in a reasonable accommodation request if you make one. And we'll also talk about assistance animal discrimination. So important to note, if you do have an assistance animal, Your housing provider shouldn't be delaying in responding to the accommodation request, and they can't restrict the breeds, size, or weight of the animal. So there's no, there shouldn't be like no pit bulls allowed, even if it's a service animal. That's a form of assistance animal discrimination. And then your housing provider can't treat you differently. So they can't charge a deposit fee or other surcharge for the assistance animal. So any sort of like pet deposits or monthly pet fees, those are not permitted if it's a service animal or an assistance animal. If you believe that you've experienced housing discrimination, there are fair housing enforcement agencies that you can reach out to file a complaint. So there's first the Hawaii Civil Rights Commission, which is the state administrative agency. The statute of limitations to file with the Hawaii Civil Rights Commission is 180 days from the last date of discrimination. And then you can also file with the U.S. Department of Housing and Urban Development, which is the federal administrative agency. The statute of limitations for that is a little bit longer, so it's a year from the last date of discrimination. And then finally, there's the U.S. Department of Justice, which is also a federal administrative agency. The statute of limitations varies. It can be 2+ years. It's also important to note that if your housing provider is, sexually harassing you, or you're experiencing sexual harassment in your housing, you can contact the DOJ and report it, and they will sometimes investigate cases if they find that the discrimination is severe or pervasive. And then if you would like to apply for our services, we do have a fair housing unit, which both Nick and myself are a part of. And the number you can call is on the screen. You can also apply online on our website. So now I guess we will take some questions, if there are any.
I think we're going to do the question and answer session at the end of both presentations, if that's okay with you. Thank you so much. This was really amazing and helpful. I know I definitely have some questions. I think Susanna does as well. And if anyone in the audience thinks of any, you can also put it into the chat and I can moderate that afterwards. And otherwise, you can just unmute yourself when we go to the question and answer session. So thank you so much, Cynthia and Nick. That was really amazing. We'll pass it over to Katie and then we will go into the Q&A.
Wonderful. Okay. Is it full screen?
It is loading. One moment.
How about now?
Perfect.
Okay, great. So hello, everyone. I am going to be talking about a slightly a different aspect of when you are renting, and that is the communication and conflict resolution side of housing issues. So first off, let me tell you a little bit about the Mediation Center of the Pacific, so you know where I'm coming from on this. The Mediation Center of the Pacific is a not-for-profit organization that was founded in 1979, which means that it's been more than 40 years, founded in Oahu or on Oahu, and it is one of the oldest community mediation centers of its kind in the nation. So during the 70s, there was a bunch of money going around from the federal government to do sort of community mediation, and the Neighborhood Justice Center, as it was called then, got some of those funds and was able to provide it. Our mission, the Mediation Center of the Pacific, is to provide high quality dispute resolution and mediation services that are affordable and accessible. We want to make sure that if people want to resolve their problems, that finances should not be a barrier to that. And we want to make sure that you get sort of the best dispute resolution services possible for that. So that's who we are. Been here for a while. When you enter into a lease agreement, when you start living someplace, renting a unit, you form a bunch of relationships, and these relationships are potential areas for friction. One of the tenets of the Mediation Center of the Pacific is that conflict is a fact of life. You're going to find it. You're going to find it everywhere. Now, it can be productive conflict or it can be destructive conflict. And productive conflict is happens when you manage it well. So some of the relationships that you are going to be forging when you rent a space for the first time, that's going to be the landlord-tenant relationship that you have. It's a very unique relationship. It's very important, and it's valuable to both landlord and tenant when it is actually working out. However, if there's miscommunication or something goes wrong, then there can be very costly consequences to it. This is a much more formalized relationship. It's dictated by rules and contracts, as the legal aid's presentation was going through. Lots of rules with that one. You also create relationships with roommates if you have them. And this one is much more informal. It can have a lot of different history to it. Some of your roommates you may be friends with for a long time or classmates with, or you may be just meeting them as you're coming together, trying to split rent and renting together. And then you also have a relationship with your neighbors. This is also an informal relationship. For many people, there's not that much communication between their neighbors unless there's a need for it. But still, it can affect your quality of life if you're having beef with your next door neighbor, or if it's a good relationship and you're swapping mangoes all the time, that's going to affect the quality of life as well. It also can affect sort of the perception of you as a good tenant. If you're not getting along with, the next door person in an apartment unit and seen as causing trouble, kind of a thing. So these are sort of the relationships that get forged that are really unique in renting a unit. And so you can try to resolve the conflict yourself. There's a bunch of different ways to do it. I don't want to get too deep into this. I'm glad that this is being recorded. You can kind of take a screenshot of this and look into it a little bit later, and then contact me if you have questions about it. I'm perfectly fine with that. If you are going to resolve the conflict yourself or attempt to do that, if you feel capable of doing it, if you feel safe enough to do so, there's a couple of things that you can keep in mind when you're wanting to address something. So if something is not, you've submitted your written repair and you want to request for a repair, you want to talk to the landlord first that this is a situation and you want to try and do something either face-to-face or over the phone, or if your roommate is just really loud and you want to figure out a way to talk to them about it, or the neighbor does something that just kind of ticks you off a little bit. They're doing yard work really early in the morning, or whatever it is. If you find yourself that there's a point of tension, a great way is to prepare for a conversation like that. So putting yourself in charge of you, recognizing your hot buttons and how you can kind of resolve it, judging where you're emotionally at this, and seeing if there are some sort of coping mechanisms that you can keep in your pocket, so that when you're in a situation, you don't get flustered or overwhelmed, and whatever reaction you might have, whether that's withdrawing and going quiet or getting louder and getting into someone's face, if that's what your instinctual reaction is for conflict, being able to assess that ahead of time and find some ways of coping with it. Choosing the right place and time to talk to the person. So if it's a roommate or a neighbor, finding a nice neutral place, seeing it's better if you can kind of figure out them a little bit, what's going to make them really comfortable, because if they're not on the defensive, they'll probably be more likely to listen to you, and find a time when they're not distracted, you're not distracted, and you can both be really calm. When you're talking to your landlord, is there already a process set in place that you can kind of fit yourself into, either one of the processes that legal aid talked about, or if there's some sort of a house rule about how you can propose something that's not legally related but is still something that's bugging you. And then finally, proposing solutions with a very open mind. So being ready to listen actively, listen to the facts that they're talking about, listen to their emotions as well, make sure that you're understanding and actually verbally checking in that you understand what they're saying, and really keeping it very future oriented. You're not looking to blame anybody. Something is happening and you're wanting to figure out a solution that is going to work for everybody. When you come into conversations like this, granted, the other person probably isn't going to be as prepared as you, and so they'll probably be a bit more reactive. So if you can get that number one of putting yourself in charge of you can prepare yourself for if somebody reacts to you in a certain way. How can you counter that with your own calm demeanor, with your own way of talking about the situation? And you might come up with a solution that you didn't think of before. You had your own thought about this is what's going to fix it in your mind, but talking to them, you find out there's a different root of the problem, and that doing something else will resolve that root cause, and the situation will resolve. This is especially important when you're talking with roommates and neighbors and that sort of a thing in the more informal relationships. Now, if you've tried to do this, or if this seems way too scary and you just want to resolve it and you could just let go, but it's not at the level where, you don't want to drag in other people. Maybe your roommate is a friend of a friend and you get the third person involved with it, and then things get complicated. An easier way to go about it is with mediation. Mediation is getting that third person in who does not have a connection with either of you. They're impartial. They want to facilitate open communication. They really want to make a safe environment for you to have deliberation and negotiation. They help people to focus on issues rather than doing personal attacks. And they're really there not because they're like good buddies with you, but because they want to help you help yourself. And so the mediator is there to really help you. This can be done for any of the relationships that I talked about, with your neighbor, with your roommates, with your landlord. And it's a way to get everybody involved in it. So why would you choose that? Because it's a confidential process. Any sort of proposed, and the confidentiality is something that gets talked over and over again within ADR, within mediation kind of circles. And so what that means really with a confidential process is that any sort of proposals for an agreement can't be brought into court and said, well, they said in mediation that they'd be willing to pay, $500 more for the next 2 months. If that's not written in an agreement at the end of it, then that can't be brought up in court. The mediators themselves are bound underneath confidentiality, so they don't discuss your matters with anyone else. They can't be called as a witness or a character witness or anything like that. And so it's meant to be a safe place where ideas can be generated and you can explore what's really going to work. In mediation, the mediators are there to help clarify areas of disagreement, to help you focus on issues, to really work on preserving that relationship and restoring trust and respect between the two participants, or more. It might be a little bit more depending on how it's going. It really helps. We found that it has helped to improve future communications, especially if you have a continuing relationship. So for things like if you are, for things like your roommates or your neighbors, you're going to be living next to them potentially going forward, and you want to continue to have a relationship with them that is respectful and effective for both of you, mediation can help to restore that and help to have each of the participants see each other's side. When it comes to things like your landlord-tenant mediation, most people see that before Act 57, where it was then mandated for the landlord to mediate prior to evicting for non-payment of rent. People often saw landlord-tenant mediation as something that just happens at court. You go to small claims court for the security deposit or an eviction, and the judge says, go into the room on the side, the mediator is going to help you work this out. And before, if you don't come to an agreement, then I'll give a judgment, kind of a thing. But it can be done so much earlier than that, so that things don't build. We've seen cases where the tenant wants something fixed. There's been something that hasn't been fixed, and so they tell their landlord to go and fix it, and then the landlord doesn't fix it, and so they say, well, fine, I'm not going to pay my rent. You're supposed to fix this thing, so I'm not going to pay next month's rent till it gets fixed. And that's what they think is supposed to happen. And so then there's a big miscommunication going on, and they still need to pay their rent, but the landlord, but they have that thing against the landlord, and so they're all taking this conflict, from not so steady places, and not talking about it, and so then that ends up in court. But if it seems like the initial communication isn't really working, mediation can help to create a plan that will help to reduce stress, because you're dealing with it, immediately, and avoid legal proceedings if the situation tends to escalate. And one of the main things with mediation is that the people who are in the conflict are the ones that are resolving it. The mediator is there to help, but it's really your conflict and your solution. And you are the best person to figure out what is going to be an appropriate solution for you. You know what you can do, you know what you can't do. They know what they can do, they know what they can't do. And so the solution is in there somewhere, and mediation is there to really help bring that out while improving communication between you. So how does this mediation thing even work? Right? You're like, okay, great. There's a safe space for it. Like, what does that even look like? Well, first off, it starts with a call to the Mediation Center to start off the whole process. We open a case for you in our system, and we talk to you a little bit about, what's the situation, what's going on, who's the other person. We get their contact information, and we find out what are some good days and times for you. We will contact the other person, say there was a mediation requested with you from this person. We'd like to schedule a time for it. Now, mediation is a voluntary process for the most part. Again, there's a couple of exceptions when laws have been put in place, but for the most part, mediation is a voluntary process. You can choose to go into it, and you can choose to end it at any point. But that works for both parties, right? We are impartial. We're a third party, neutral to it. I often like to call it multi-partial. It's not that we're not on anybody's side, we're on everybody's side. We want everybody to be able to solve this and have it be something that really works for you. So we will let them, we call them to say, we would like to schedule a mediation session. They can decline at that point. If they decline, then we'll let you know about it, and we can issue what's called a mediation status letter that shows that you attempted mediation, but then it got declined by the other person. If they say yes, and hopefully they will, right? Because they want to work it out too. Most likely they've been affected by this conflict as well. Maybe they didn't know how to approach it, right? So then we'll find a time. Time is scheduled Monday through Friday. We've got 9 a.m. and 1 p.m. slots for 3-hour sessions. For some of the landlord tenant cases, we've been doing 1.5-hour sessions. And so then that's 9:30, 10:30, 1, and 2:30. But when you talk to our client services, we'll figure out kind of which is the best format for you. And then these can be in person or remote, and it'll be through a Zoom conference. And the in person or remote is based on your, not only your preference, but also what would make you feel safest and more able to actually engage in the mediation. I will say a majority of our cases right now are on Zoom, but more and more as restrictions have been lifted and that sort of a thing with COVID, we've been seeing more people come in person, because part of it is being able to talk to the other person in face-to-face, actually face-to-face. But you'll decide on what's a good session date. We'll go back and forth, and then you'll go through this mediation process. Now that's what this little funny diamond is here. And this is just a visual to help you kind of understand basically what mediation is going to feel like when you go into it. It's going to start off with the mediators explaining who they are and what the situation is. They're going to talk to both people, and they'll both be in the same room or on the same Zoom screen. Tell me about the situation. And the mediators, one person will be talking at a time and finding out, okay, tell me a little bit about what's going on and where this point of tension is, where this point of conflict is. And they may keep you all together in the same room if it seems like it's a productive conversation. And they may at some point move into private sessions. And so it'll just be you and the mediator talking, and they'll get a little bit, maybe a little bit deeper into what some of the issues are, maybe what, kind of what's going on with it. And the confidentiality, now I said that it was about they can't testify in court, but it also applies to these private sessions, which means that you can say something to the mediator in that private session and say, but I don't want you to tell the other person. And then they will keep that confidential. They may ask you later on if they can share it, if they think that it's going to be something that will help you get to an agreement, if only the other person knew. But in general, and for the most part, except for certain exceptions, right, then which they'd ask you about it, but you can still say at that point, no, I don't want you to share, and then they won't share it with the other person. So the mediators will keep those parts confidential. So we'll have private sessions. And maybe it seems like the mediator listening to both of you and sort of ferrying some messages back and forth sees that there are points where you have agreement, where there might be some solutions here. And so there's kind of that turn from that talk story, what's the situation about, to, so then how can we resolve this? What can we do that will help to maintain this relationship going forward? That'll help to, to resolve these points of tension. And so there'll be some solutions going back and forth. That might be in private sessions, that might be together if you can communicate well enough and the mediator sees that that's going pretty well. And then when you finally have terms of an agreement, the mediator will help to draft it. If it's on Zoom, you'll see it on the screen in front of you. They'll share screen like this, and they'll write out each of those terms, and then it'll get sent to you for signatures. And then you'll both have a copy of a signed agreement, which will act kind of like a personal contract between the two of you. You'll do something, they'll do something, and that kind of agreement can help to resolve the issue and be part of a plan moving forward. It can include communication. It can include like with your landlord payment plans. It can include behavioral things, time limits, how loud music is. It can be very specific, before, between 8 and 10 is when I do my homework. And so if you can keep your music lower than number 5 on your computer, like that could be part of an agreement. It can be very specific to that. And that's kind of coming together and having that signed written agreement at the end. And now, again, with a voluntary process, at any point in this, if you feel like it's just not working, it's just not going to happen, you can end the mediation. It's just not working out. So it really is your process. The mediator is there just to facilitate it. And so then the intent behind that is because you've been so involved in the process and it has come from you, from both of you, right, who are in this conflict, that the written agreement at the end is something that you can truly do. You can enact that agreement, that you can follow through on it because it's yours. It's what you have proposed. It's what you have agreed to, as opposed to, say, in a legal process where the judge says, this is what's going to happen. And then you just have to do that. So that's kind of where a lot of the power of the mediation kind of comes into. So how do you schedule it? Well, we've got 2 different ways that you can do it. One is by requesting a mediation online. And so we've got our website right here. We have a specific link for if you're getting referred from district court, but you would press that yellow button on our website, and that will ask you a bunch of questions. Now, the Mediation Center of the Pacific does a ton of different types of mediation. So you may find some questions there that have nothing to do with this. How many kids do you have? Is there a court case involved? And you might be like, no, none of that. And that's okay. You just skip those and move on with what actually applies to you. Or you can call in. And so I've got two numbers up on here, the 521-6767. That is our general intake line. And so that's for if you've got an issue with your landlord tenant, with your landlord, if you've got an issue with your roommates, and it hasn't gotten to the point where it's in court, where you're being proactive about it and wanting to resolve it sooner, you'd call that one. If it's specifically that Act 57 mediation, there's a slightly different process for it. So if you receive that 15-day notice for non-payment of rent, you call this number. There's going to be there's a couple of different hoops that we kind of have to go through because of where the funding's coming from for that. So you'll still talk to a client services specialist. They might ask you some more information about like how you've been affected during COVID and those sorts of things before they work on scheduling. And for Act 57, because it is this limited time, very specific program, it's a little bit more open in terms of scheduling. So we're able to schedule at less regulated times for it. The Monday through Friday, 9 a.m., 1 p.m., or 10:30, 2:30 for generalized mediation. So things where you're trying to be proactive about resolving it. You'll talk to our client services specialists. If you submit online, they'll call you, find out a little bit more about what's going on, make sure that they have the right numbers and everything like that. And then they'll contact the other person, kind of go back and forth on the phone, finding a convenient time. If you are going to be mediating remotely, you will have a confirmation email that'll have the Zoom link to it. We also will give you a link to our website where we have some things about preparing for mediation and what you can do ahead of time to make sure that it can be the most effective that it can be. If you elect to have an in-person mediation, our office is located at 1301 Yonge Street. We are kind of in between Makiki and Ala Moana, by the Easy Music Center and Kidney Cars, if you know that, on King Street. This building that you see here, this is all ours. You'd be up on the second floor to do the mediation. Entrance to parking, which is free for our clients, is on Yonge Street. So you'd come in, we'd welcome you in there, and we'd have some rooms for you on the second floor. And so that's kind of how it would go. You can ask our client services specialist when you call in or when they call you any questions that you have about the process or anything else going forward. And they are very able to answer any of the questions that you have at that time too, if you're calling in. And so that is just the last thank you for being part of this and for listening to what I have to say about this. I do hope that you'll be able to integrate this into aspects of your life, whether it's housing issues or anywhere else. Mediation is applicable to a lot of different types of conflict. If you want to call me, you can call the main line and ask for me, and they'll transfer you to me if you want to talk to me in person, or you're very welcome to send me an email, and I will be happy to answer any questions that you have kind of after the fact. I won't be doing kind of the same disclaimer with legal aid, not really conflict coaching on like how to prep you into doing specific conflicts, but I can answer questions about the mediation process, whether I think something would be good for mediation, and then I can transfer you to client services from there. And then we've also got our website. We've got a lot of information up there if you'd like to look into that. So thank you so much.
Awesome. Thank you so much. Can we all use the reactions to give a big round of applause to all three of our speakers? Yay.
I'm really glad you have this recorded, because that was very rapid fire for all of you. So if you missed something, you can watch it again.
Yes, we will definitely be sending out the recording in addition to some other resources that we've compiled. Shout out to Caroline Kunitake. Thank you so much for all of your help with that as well. And we will be sending the websites and things like that so that people can follow up. And then at this time, we will move into the Q&A session. So if people feel more comfortable putting questions into the chat, I can read them out. And otherwise, if you raise your hand, we can call on you and you can unmute yourself and ask some questions. So is there anyone in the audience who has anything to ask? And otherwise, oh, yes, Caroline.
Hi, thank you so much. I'm actually part of the leadership team for AAUW Honolulu, and we really appreciate your time, and this is your evening. My question is for the attorneys at Legal Aid. Oh, I have someone asking a question, but I'm curious to know, during the pandemic, what type of cases did you handle most frequently?
It's a good question. I would say generally, we handled the same type of cases as we normally did, but there was obviously an increase in non-payment of rent cases, right? For understandable reasons, folks losing their jobs and having difficulty making ends meet. So we definitely saw an increase in those type of cases. But kind of going to the fair housing end of things, we certainly saw the same type of issues. Actually, I will say, and Cynthia, you might have additional perspective on this too. I do think we probably saw an uptick in sexual harassment, like quid pro quo situations. I think kind of dovetailing off of the idea of the non-payment situation, I think landlords that act in bad ways kind of see that as an opportunity, right? So I think if they have a vulnerable tenant that can't make rent, I think there's certainly an increase of those type of cases. But I don't know, Cynthia, do you have anything else on that?
I don't know that I would say that I saw an increase in like domestic violence related cases, like involving fair housing issues related to domestic violence. But I think there was for a while a big concern and a big uptick in domestic violence in general, which now I feel like we've gotten kind of a steady flow of, you know, those types of cases. But yeah, definitely, I mean, non-payment, we're still kind of trickling out of that. And then, yeah, fair housing is pretty much the same.
And then to Katie, I know you're a mediator. I've actually been trained in mediation, and I don't know if our audience members are really familiar with that kind of service, but I heard that the Mediation Center was preparing for an onslaught of mediations. And I heard that it didn't happen to the extent that the Mediation Center was expecting. Is that true?
Yeah, so before Act 57 came into place, we were really expecting just like thousands of cases in the first month. Just that all landlords who had any tenant that hadn't been paying rent and was only not evicted because of the moratorium were all going to send it in all at once, and we were going to just have thousands of them. That didn't happen. What did happen instead was that there was a somewhat large but more steady flow. So from August of last year, we've been getting in anywhere from 150 cases in a week down to maybe 40 or 50. But that has been consistently like that with certain peaks. We were actually talking about this before recording, that there are certain times when a whole whole apartment building would get their notices all at once, and so then we would have a huge peak that week of cases coming in. But it's generally been a smaller number than we were expecting, but a steady number throughout the past months.
Thank you. I see the questions coming in.
Yeah, thank you so much for starting us off, Caroline. And thank you guys for your responses. So we do have another question in the chat, and that is a credit score required to rent? Because some people, of course, don't have a credit score. And is there a way to be able to rent if you don't have one or if you have bad credit?
So that's a good question. And I'll kind of start it, and I know Cynthia probably has some thoughts to add here. In terms of if a credit score is required to rent, it's going to honestly depend on the landlord. Some landlords are going to, really care about that information, and some are not going to the same degree. So source of income is not a protected class in the state of Hawaii. So it would be legal for a landlord to request credit score and try to understand credit history prior to renting. With that being said, certainly you can imagine circumstances in which credit score could be used in a discriminatory way, right? So whether that's because, generally younger people are not going to have the same type of credit or credit history as older applicants might. There's a few other protected classes that you could kind of parse through and understand the disparate impact of that. So it kind of depends on how it's used, but generally speaking, it's okay to ask for that information. Typically a landlord in that situation would ask for a cosigner, would typically be how that would work. If there's someone, in your life, whether it's a parent or a family member or, older sibling, whoever it might be, that could sort of provide that guarantee on some level to the landlord that you'd be good for payment, even if, you couldn't make it for that reason. That's typically how a landlord would do it. But the short answer is, yeah, they could ask for that information and use that to determine whether or not they would rent to you.
Yeah, I don't think I have a lot to add to that. That's great.
Awesome, thank you. And then another question was, what are red flags to be aware of as a renter? And I think that would go both to legal aid, and then Katie, also perhaps the cases that you usually see at mediation centers. So things to maybe look out for early and try to mediate early so that it doesn't get to the point to need mediation.
Wow, I can start that one. I guess it would start with the advertisement. Note that, when we're talking about fair housing laws, they also apply to advertisements. So advertisements that say, females only, or advertisements that, say, no assistance animals or something like that, you can report that. You can call us and for assistance, or you can, contact those agencies that we talked about, HCRC or HUD, and file a complaint there. And then in terms of, I guess, other red flags, I would say, like Nick said earlier in the presentation, you want to make sure that you do some sort of walkthrough before you, go ahead and sign a lease, because you may get there and find that the condition of the property is not what you thought it would be. And you want to make sure that you're documenting things as best as you can, so that if any issues pop up, you have a trail.
Yeah, I would just add a little bit to that. And that was, I think, really helpful. I think, to Cynthia's point, I think when the rental market is as competitive as it is here generally, it feels kind of a little bit like a rat race to try to find a place and get a place, and you feel like you need to kind of push extra hard to, get into whatever unit. If you don't see the place, who knows, right? You see the listing on Craigslist or, apartments.com or whatever. Try to view the place if at all possible. Renting sight unseen is really tough. And if the landlord's insisting, I need this deposit, I need you to do this, I need you to, fill this out prior to having a chance to actually see the property, you're really setting yourself up for potential, bad outcomes there. Similarly to the point I just kind of started to make there with the money, really you shouldn't be required to be putting down money unless you are either, you're signing a lease and you're making a deposit, which is a valid reason to put money down, or in some cases they're going to ask for money for a credit check or, process the application. Might be a relatively nominal fee, $30, $50, whatever. That's legitimate. But if a landlord's saying, I need $500 to consider you for this unit. I need it by, 4 hours from now, whatever. I mean, be very weary of someone that's demanding money that quickly. There's probably something else going on there.
I would just add to that. I would first like to reemphasize the yes with the documentation, yes with seeing the place first, and yes with meeting with the person that you would probably be dealing with the most often. So if there is sort of a residential manager as well, somebody who's just in the apartment building who manages with that, meet them first too. A lot of times what we've seen is when people are coming in and asking for mediation, they're like, I should have known, they did such and such a thing ahead of time. They were pushy when we were talking to them. I had a weird feeling they kept on trying to skip over the walkthrough or like brush things off. I should have known. Going with your gut feeling on that, I think is very important. If there's somebody who you like, it just makes your stomach sink if you're like, I'm going to have to talk to them every month. Don't rent from that place. It's not going to be a great place to live. And if you're thinking about like, I get other people's opinions. They have a lot of websites right now that are about rating property management companies and different apartments and how it's like living there. Go and do a little bit of research ahead of time and find out. But yeah, definitely document. You watch this video again. You know what to do when you're going into renting. If the landlord is trying to swerve you on any of these things, it's not a great sign.
Thank you so much. And it is 7:30, but we do have a couple more questions. So I guess to the speakers, if you would be okay with staying on a little bit longer, we can continue with some of the remaining questions. And otherwise, if any of the attendees do have to leave now, feel free to email me with your questions and I can maybe forward those along with the resources and then get back to you on those. So I think that kind of comes up to speakers. Would you guys be okay with staying for a couple more minutes?
Sure.
Okay, wonderful. In that case, one of the other questions was related to a previous question, which was, what do you do if you don't have a co-signer? And I think this went along with the questions about also not having a credit score.
Yeah, so unfortunately, kind of going back to what we'd mentioned earlier, there's no real protections in this case, right? So if a landlord wants to do credit check to understand whether or not you're going to be able to, or are more likely, at least in terms of how a credit report works, more likely to be able to make monthly payments or not, they're going to require a co-signer. There's nothing that would prohibit them from denying your application because you don't have a co-signer, which is really unfortunate because obviously there's a lot of circumstances that folks might find themselves in where they don't have a co-signer for a variety of very valid reasons, but there's really no protections in that case. But certainly there are landlords out there that wouldn't have the same type of requirements. So hopefully there would be other options that would be available. But short answer is there's really not a great, great response to that other than the landlord is entitled to do that.
And I believe there is, the name is escaping me right now, but for people with no or low credit scores, there's like an introductory type of credit card that you could do. That's not actually a credit card. I'm not remembering the name right now, but I'll figure it out.
I've heard that. I've heard of that one as well. It acts kind of like a debit card, so you can't actually spend more money than you have, but they do it. Yeah, there you go.
Credit card. There we go.
Secured credit card. Mm-hmm. Helps build your score.
I have a question if I can ask, unmuted. So my question is, so let me paint a scenario. So let's say they've done the rat race, as you guys call it, when you're hunting for a place to live, a rental. And for some reason, they can't seem to connect the dots and they are running out of options. So in our society, and in particular in Hawaii, what are the safety nets for people who happen to just slip through the cracks? If that makes sense.
Can I just ask for clarification? Sorry, when you're saying slip through the cracks, are these folks that for either the reasons in the previous questions or other reasons that they don't otherwise qualify for a rental or don't kind of meet the protected classes that we talked about earlier, where they would have a complaint for discrimination, like they're unable to rent for one of those reasons? Is that the question?
Sure, yeah. Like, let's say they don't have a credit score and they don't have a cosigner. Maybe they are renting somewhere in particular, like in the city, but they can't find a place at all. Like it's just they just can't somehow to find a place to live, and they don't really have that safety net to fall back on, like family or friends. What
Mhm.
resources are there out there in the state of Honolulu, in the city here, that someone can rely on?
I think that's a great question. Nick will allow me to jump in. So one resource that we commonly refer people to is 211 to find resources that are specific to your needs. For housing resources, there is actually a program that connects landlords with tenants that just recently came out through Partners in Care.
The landlord engagement program.
Yeah, landlord engagement program. So thanks, Katie. I will put that information in the chat for anyone who's interested.
I would also say that there are there's some housing assistance through the American Job Center and the Workforce Development, Council, the Workforce Development Council. They assist people with finding appropriate housing and can kind of act as, you know, as a they're not really like a cosigner, but they help them to get into housing if they're in situations where it's difficult to get something on their own. It does come with certain certain restrictions to it. You need to be engaged in the program, and there's certain things for along the lines with that. But that it's kind of a sideways coming into it because they're not exclusively about housing, but they do have programs that assist with that. And I can put that in the chat as well. They've got their website.
Thank you, guys. So wait, is it literally 211 a number? 211?
Yeah, it is. It's Aloha United Way.
Oh, okay.
Yeah.
I had to ask that question because it's really scary. COVID made it even more scarier when, you know, people lose their jobs and they're having a harder time to make ends meet. And then there's something called Section 8 housing assistance, and checking on their website, their wait list is always closed. So it's really hard to find where to go and to know where to go specifically to get to find a place to stay. And may I also add that I only know so much, but this is only my perspective. It's very, very frustrating to see within the city how there are more private interest than public interest in terms of housing. It's very frustrating to see condos being built, so many units, like hundreds of units out there, but completely outside of the local income. It's very frustrating to see that. So it's like it's either you find like these, you know, somewhere like 3, 4, 5 miles outside of the city kind of rentals, or gotta find a roommate. But yeah, it's just the struggle to face as a local here.
Could I mention something really quickly? I think at the city level, Mayor Blangiardi just signed, I forgot which bill, and it's going to limit the number of short-term rentals outside of the tourism industry areas like Waikiki. So I'm going to assume after a while that may open up more long-term rentals in various areas. Is that a fair assumption among you housing advocates?
I'd say we don't know what the outcome is going to be of that. It's hard to predict on what's going to be the the snowball effect of what's going to come from there. We can hope that opens up. I think that's what they're trying for. We can hope that that's what the outcome ends up being.
Great. Well, thank you for being here. And thank you so much. This was extremely informative and helpful. I definitely wish I knew all of this before kind of going through the process, so I hope the recording will really help some students, especially just because I think that's frequently it's from that transition out of college, or your last 2 years that you start to transition on. Susanna, yes.
Sorry, if I could ask my questions really quickly.
Yes.
It's a like probably yes or no question. Is there a way to find out if landlords are paying taxes on their rental properties as a potential renter?
Yeah, well, so each county has public property records. I
Okay.
believe the tax records are also included on there.
Okay, awesome. And is there ways that a person can make a complaint to a specific landlord through research complaints against a specific landlord?
Sorry, research complaints?
If they can find if there are complaints against a specific landlord.
Oh, okay.
Mhm.
Go ahead, Nick.
Yeah, so the judiciary maintains effectively the database of all of the filings. So you can search, it's called eCourt Kokua. We can post it in the chat here, but you could search the landlord's name and you could see the history of complaints that were filed against that landlord.
Okay.
You're not able to access the actual filings necessarily. You might have to pay for those to see, but you can see, this landlord's had 15 cases or whatever. So that's all public record if it's been filed in the state courts here. We can post that in the chat.
Yeah,
Okay,
and
awesome.
the eCourt Kokua is actually, well, it's the court's online records now for both family court and district court. And if you search the landlord's name, you may find criminal records, or you may find, district court TROs, or you may find, complaints for summary possession, otherwise known as evictions, that maybe the landlord has filed themselves.
Awesome. Thank you.
You'll see everything from traffic violations to probably what you would be interested in is like if their tenants are filing for the security deposit, like Nick had talked about previously. If that comes up a lot for that, you'll see it there, at least in a summary form. You won't get the full documentation because you do have to pay for that if you want that, but there's enough in the summary form that would give you a general idea of some things that have happened.
Awesome. Thank you.
On that, can I ask one really quick question as well? I forgot to ask it too.
Mhm.
Are there any protections for other tenants in a house if there are cases of like sexual harassment or domestic abuse going on that where there's no evidence, so the person hasn't been evicted?
So yeah, I mean, if there's like a tenant that's sexually harassing another tenant, then it's important for the tenant who's, the victim of the sexual harassment, to report it to their landlord. If their landlord fails to act and prevent that sexual harassment from occurring, then that person may have a potential fair housing claim.
Awesome, thank you.
And if that's coming up, I would say to also contact someone who can assist you, like DVAC, the Domestic Violence Action Center. Especially if it's about that. I find that if you call in and ask for assistance and make it clear, if you're looking information wise, make it clear that you are just looking for information as opposed to somebody to represent you in court, then you can get into the right place for that. But if you do need an attorney for something along those lines, it's good to be clear about what you need and what kind of support that you're requesting.
Wonderful.
And, sorry, if I could just tack onto that, me and Nick are part of the Fair Housing Unit and the Housing and Consumer Unit, but we actually have assistance for other matters as well. So we do have a family unit that I believe handles family court TROs for people who are experiencing domestic violence.
Good. Well, thank you all for being here so much and for letting us go over for like 15 minutes. I know it's been a big chunk of your evening, but this is definitely going to help a lot of people and we greatly, greatly appreciate it. So, and thank you for everyone for being here today as well. And with that, yeah, I guess just a good night. And again, thank you so much.
Thank
Thank
you.
you, everyone.
Thank you.